I'm here to answer some of the questions people ask me. And people ask me, what do you do? I say, I'm a member of the Human Rights Tribunal, and they say, oh, that's wonderful. What do you do? And so, because I think it's not widely known what the tribunal does. And so what I think is important to understand is that the tribunal doesn't investigate. It's a complaint-driven process. It used to be much more involved in investigation and so forth, but at that time there was a human rights council and a human rights tribunal, and the council performed if you want, educational aspects and provided counsel for complainants and so forth. None of that is available anymore, but what we have instead is a faster process. The council ended up being a process that just took far too long for complaints to get from one end to the other. So I joined the tribunal 5 years ago. I'm just about in December to start a second term, which is nice. The Human Rights Tribunal is a creature of a statute called the Human Rights Code. And the focus of that code basically is an avenue to deal with human rights violations that occur in the province. The purposes of the code include the promotion of a climate of understanding and mutual respect where all are equal in dignity and rights. That's kind of fundamentally what the code is about. As I say, it's complaint-driven, so we receive a complaint in the door and then the process starts. The nature of the area of complaint is manyfold. We have, and what I would like to say at this point, just before I really get into this, is that if you have questions about what I'm saying as I go, please just stick up your hand. The code is limited in its scope. It's not a complaint-driven device on a broad scale, which people sometimes seem to forget. We get lots of complaints that are complaints, valid complaints maybe in many cases, but they're not human rights complaints. And so what I want you to understand is, what we do. And that is governed to a degree by the nature of the areas that complaints fall under. And I think primarily for cerebral palsy individuals, that will either fall into the area of services that are denied or tenancies, perhaps, that are denied, or property purchases which somehow run afoul of discrimination, and wages and employment. So the grounds are many. With cerebral palsy, the ground invariably would be a physical disability. And that is one of the grounds of discrimination under the code. The others include race, place of origin, ancestry, and color, all of which you might, kind of group in a particular area, although they each have different meanings. Religion, marital or family status, mental disability, sex or gender, if you will, sexual orientation, and age. Those are the grounds that we deal with. So For example, a woman is pregnant and leaves her job on a pregnancy leave, is ready to return to work a year later, as she's entitled to under the Employment Standards Act, and finds out she doesn't have a job anymore, and believes that that relates to the fact that she's pregnant, will have a child, and that the employer is concerned about that going forward. That's the kind of complaint that we deal with. And our job is to determine, because invariably in those situations, there's another side to the story. The employer may have done a reorganization, eliminated the role. There are a lot of things that could have happened that, or that can be claimed to have happened, that color the circumstance and make it necessary to determine what actually happened in order to determine whether a discriminatory conduct has taken place. So that's our job. That's part of our job. That's what a complaint is about. And the basic complaints process commences with the complaint itself. And it has to be filed within 6 months of the behavior which is alleged to be discriminatory. And there are exceptions to that. I can deal with them, and will deal with them a little bit, but mainly it's 6 months or you're out of luck. And so the complaint will lay out the area of discrimination, employment, service, whatever, and it will lay out the ground of discrimination and the facts that are relied on to support that. The respondent, yes?
Is it a rolling start? Like if you have continuing discrimination, is it 6 months from the first instance, or does it all get looped into whatever?
Well, it's kind of the other way around. It's a really good question. There's a concept of continuing contravention. So if you have, as you say, a series of events that can be seen to be separate events of discrimination but are of essentially the same nature, then as long as one of the last of those events is timely, and you can convince the tribunal that it is indeed a continuing contravention, then you're in time. It's not out of time. There's also, as long as we're dealing with that, there's a discretion to allow untimely complaints to proceed if basically if there's no prejudice to substantial prejudice to the respondent, and if there is a public interest in having it proceed, and that might include a unique kind of complaint, like the one I described is pretty normal, but there might be one that comes up that's unique, that the tribunal thinks, well, we should hear this. This is something that really needs to be addressed, either because of its unique impact or because of its unique set of facts. And so in those circumstances, a tribunal member will be asked to determine whether it's timely or not, and can apply that discretion, even though it's out of time. And of course, how much it's out of time will matter with respect to that. If it's a couple of days out of time, it's a pretty easy hurdle to make. If it's 10 years out of time, it's going to be pretty hard to make that complaint stick. Okay?
You have a question?
Yeah.
So does that determine timeliness? You already mentioned that human rights code is limited in scope.
Yeah.
So is it the job of a tribunal member to expand the scope if the case is unique?
Well, you can't expand the scope. The scope is laid out in the code. So, you know, we don't have any jurisdiction beyond what's laid out in the code. But you could have a circumstance that was quite different, that fits within a particular ground that's laid out in the code.
Oh,
Yeah, yeah,
so that you determine, tribunal member determine.
yeah, 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 yeah. So what happens is that complaint comes in and it gets screened. And the reason it gets screened is because, as I've said, there are a lot of complaints that come in that aren't really human rights complaints. You know, they're complaints, they're people being people. There are always complaints. You know, people don't like how they've been treated by somebody, or they don't like the fact that they've been terminated, but they're unable to connect it up with any particular ground. And so the screening process is designed to weed those kind of complaints out and let us concentrate on what I would call real complaints. And it's important to realize that there, you know, including the chair of the tribunal, there are only 8 individuals who deal with the things that I'm going to talk about, and 2 legal support people, as well as, you know, the case managers and whatnot. But there are only 8 adjudicators. So there's only so much resources available. So screening is an important process to make it all function. When the complaint is accepted, it may be accepted on the grounds that have been presented, or it may be accepted on only some of them. You know, for instance, if the complaint reveals, if the complaint is based on religion, sex, and employment, or rather, let's say a physical disability, it may be that the facts, you know, really only go to physical disability and sex, but not to religion. So the religion would be weeded out, and the complaint would be accepted on the other 2 grounds. And then what happens is that the complaint is sent out to the respondent. We try and get it out promptly. There was a time when it took a long time to get it out. But now, you know, the respondent usually gets the complaint within, you know, a month, max 2 months kind of thing. The parties are encouraged to engage in mediation. And a healthy number of parties are interested in mediation. And the members of the tribunal do serve as mediators under the code. And so what happens is mediation, some of you may know, or all of you may know, that mediation is essentially a process where the parties try and forge their own settlement. And what a mediator does is to try and create an atmosphere which is conducive to that. Sometimes I think that people come to mediation kind of expecting that the mediator will get the other side, set the other side straight so they can see things the way that they should be seen. But that isn't the job. The job is to create an atmosphere that's conducive to allow the parties to settle. And my experience is really very positive with respect to mediation. The success rate is over 75%. My experience is that when people sit down and try and work out resolutions, they get committed. to finding a resolution. One of the cases that Fiona asked me to speak to is Winkelmeyer. And it's a case where a young man was looking for summer work as a housekeeper in a inn or hotel, and didn't get the job, didn't get past indicating that he had some restrictions, and as a result of that, was successful in a human rights complaint. But the question is there, do these cases have to be brought individually, or has there been a systemic decision which lays out in broad terms that there is this obligation? Well, the answer is kind of both. Every case has to be brought on its own merits. Winkelmeyer was a case, I actually was the member on that case, and Winkelmeyer was a case where there was conflicting evidence about what occurred. Mr. Winkelmeyer, had read between the lines of what was happening and viewed it as discriminatory, but didn't really push it far enough that he forced the employer to say or do anything that made it absolutely clear, and left openings for, if you will, a little bit of prevarication from the employer's side around what was going on. And he was lucky that the individual who was giving evidence didn't do a very good job for the employer, and it became fairly clear that they weren't reliable. What needs to happen is, when you're faced with those kind of circumstances, you do have to carry on and do your best to get to the point where they're not going to. It's very seldom in this day and age that somebody's going to say, well, we're not hiring you because, of your situation. But to try and push it far enough, and, for instance, he had worked doing similar kind of duties for another employer. It was on his resume and so forth. And you want to make sure that that kind of information is presented to the employer. So there can be no question the employer knows that. And it helps to make the case later, right? But every case is, Winkelmeyer is no exception, has generally got some broad principles stated, which are going to be applicable if the facts fit. But there's nothing that says, for instance, that a person who has cerebral palsy or any other physical or mental disability is, in such and such circumstances is always going to be successful on a complaint. What you can do is you can say in those circumstances that the Human Rights Tribunal is there, and if there are good reasons, you're prepared to go there. The trouble with that, in my view, is that all you do is alert person that's an offender to the fact that they need to have other reasons. And then they tell you what those other reasons are, and your case is kind of gone. So it's always a bit of a problem because it's always about the facts. At the end of the day, what a complainant has to do is prove what's called a prima facie case of discrimination. So they have to prove that they're disabled. They have to prove that they've been adversely treated, which comes with not getting the job, or not, in this case, even being allowed to apply for it. And they have to prove that there's a connection between those two. There's a connection between the disability and the adverse treatment, which can be very easy in certain kinds of cases and much more difficult in others. Because individuals who don't want to employ people with disabilities usually have some other reason that they express, or don't express any reason. And then once the complaint comes in, they figure out what they want to say, and then they say it. And then it's up to the tribunal to sort it all out and decide whether or not there is a connection between those two things. So it's not a simple answer, I'm afraid.
Mr. Trier,
Yes.
just to follow on to that, so if you take the step of going to the tribunal rather than raising this decision with the employer or potential employer, before the tribunal, do previous tribunal decisions have any precedential value? If they've been judicially reviewed, do they have more precedential value, or do you always go back to first basics of the code?
Oh, no. Precedent is very important. Yeah. And so a case like Winklemeyer is important because the next case that comes in front of a member, that case is there. The parties will refer to it. The people that like it will refer to it in positive ways. The people who don't like it will try and distinguish it, say it's different from what is in front of the tribunal now. But it's always something that the tribunal can go back to as a grounding. So the cases of first instance are the ones where those kind of precedents are set. And then what you usually get is a string of ultimately many such cases. And you can go through them when you're a party, and you can pick out the ones that you think are the closest to your case. And when you find one that's close to your case that you like, you put those. When you find those that are close to your case that for some reason have rejected the complaint, you find out and point out how it's different. But that's really more of a council related issue. The tribunal is intended to be available without lawyers. And it is. It's available without lawyers, and there are many cases where one or both parties come to the tribunal unrepresented. And, I've got to say that it's one of the huge advantages of the commission, which Human Rights Commission, which existed previously, was that it provided counsel to complainants, because human rights is a complex area. It seems simple, but some of the concepts are pretty hard for lay people to grasp and argue effectively. It's always better if represented by competent counsel. But we do what we can to try and even out the playing field when that's not the case. So mediation is intended to allow people to settle. And you know what? It works. If you're ever involved, it would be a poor strategy not to engage in mediation. Because saying you want to mediate doesn't mean that you have to settle. It means you can attempt it. And if you can't, then it just goes back into the system and it goes along as it would have if you had rejected mediation. My experience is that sometimes I look at files and I say, oh, this is never going to settle. And it just does. And sometimes it's straightforward, other times it's wonderful. Because in mediation you can get results that you can never get in a hearing. A hearing is I'll get to what remedies look like, but in a hearing the remedies are pretty straightforward. You get You get declarations that there's been a violation of the code. You get orders that are intended to make the person whole, and you get something called an injury to dignity award. But that doesn't fix it for somebody who maybe maybe somebody's coming from Romania, and they've had education in Romania as an engineer, and they're coming to British Columbia, and they want to be certified as an engineer. There's certain requirements around that, and some of their credentials aren't accepted. And sometimes there's a good reason for that, right? Sometimes there's a very good reason for that, and sometimes it's hard to see the reason for that. And, you know, place of origin, that's a place of origin complaint. And sometimes you can get in there and you start talking, and you can find solutions to situations like that allow somebody a chance to get qualified and work in their chosen profession, which isn't likely to be coming out of a hearing. So, you know, and sometimes with respect to education issues, somebody, well, cerebral palsy victim, a child, might be encountering problems in the school that, you know, you get to a hearing, it's going to be darn difficult in terms of remedy to deal with that in a way that's really going to be satisfactory to anybody.
Sorry, but I still don't get the difference between hearing and a mediation. Could you explain this first again?
Yeah, sure. Well, a mediation doesn't involve witnesses. A mediation is just a discussion between parties where they're expressing what their interests are. They're expressing where their disappointment lies and what occurred. And the idea of mediation is to allow parties to see the other side's perspective, which can often lead to a shift in the perspective of one side or the other that allows a breakthrough. A hearing is a trial. Rules of evidence that are applied, maybe a little less than a full-blown court hearing, but very much similar to a court hearing. Yeah. So eventually, at the end of the road, that's what you come to, if you can't settle it earlier. But before you get to that, there's something called an application to dismiss. Respondents have the right to make an application to dismiss a complaint on certain specified grounds. You know, a real simple one might be that somebody in the federal prison system, a prisoner, makes a complaint to the British Columbia Human Rights Tribunal, and we go, well, do we have any jurisdiction to deal with this? And if the answer is that it's federal, then no, we don't. And the person, you know, the prison system would apply to dismiss it on the basis that we don't have any jurisdiction. So that's another kind of decision that takes up, I would say a mediation takes up maybe 50% of members' time. I would say that applications to dismiss take up another 35% of members' time. And hearings actually take up maybe 15%. There aren't that many cases that go to hearing. I might do 4 or 5 hearings a year.
Are mediations done without prejudice?
Yes. They're absolutely confidential.
So you would have a different tribunal member if it went to hearing?
Yes.
Okay.
Yes. Tribunal member who mediates is not going to hear the case. As a matter of fact, won't have any more involvement in the case. And so you got that. And then you got disclosure, you know, disclosure processes where documents are required to be produced that are potentially relevant. You know, it's a pretty broad disclosure requirement. You know, the tribunal isn't interested in having a party decide what's relevant and not relevant. So it's broad enough that it flushes out documents that might be relevant, and then at the end of the day, the parties can decide for themselves whether they want to argue that there's relevance. But we oversee all of that. So when I talk about hearings, I'm also talking about management of the process to hearing, which includes disclosure, people complaining that they haven't got the documents that they think they should have gotten. You know, there's a mention in this document of some other document that I never got that, you know, might have been, I should be getting, and the other side says they don't have it, et cetera. So we deal with that kind of stuff along the way as well. And then there's the hearing. And, you know, hearing is, it's just better if you don't have to go to a hearing. It's a tough, hearing is a tough process for everybody involved. And I just say that because, you know, anybody who's ever gone through a hearing knows that they're unpredictable. You may think you have the best case in the world, and you may find out you don't. And the other way around. Somebody may think they're on shaky ground, and when they get there, they find out, you know, that the evidence is okay. They're all right. All of which means it's always better to make your own deal if you can. Now, applications to dismiss I want to discuss in a little bit more detail. They're made by written submission, which is a big difference between that and a hearing. And sometimes those submissions are in affidavit form, so they're evidence, they're sworn. Often they're not. And occasionally the tribunal will latch on to that difference. I'm not convinced it's usually a very good way to go because, you know, you're often talking about people who don't even understand the difference between affidavit and just a handwritten note, you know, that says X or Y. So generally, I'm of the view that if somebody is an unsophisticated litigant, if you want, that I'm not likely to be preferring some evidence just because it's in an affidavit form. Sometimes there's a war of affidavits. You know, if somebody's swearing things happen one way, somebody else is swearing it happened another, which is just the same kind of thing that any court gets. And our job is to basically sort out the wheat from the chaff in those circumstances. And on applications to dismiss, that might mean that you can't make a decision. It might mean you just have to say, sorry guys, you know, this is just too close to the bone and it has to go to a hearing and be subject to cross-examination and so forth because I can't decide which to prefer. You're not really supposed to be making findings of fact in an application to dismiss. Although it's a fine line between making findings of fact and making decisions. Well, let me just deal with the bases for a dismissal. There's jurisdiction, like I mentioned, okay? There are acts or omissions that don't contravene the code. In other words, somebody's saying that they were discriminated against, but when you really look at what happened, it's not discrimination. There are others where there's no reasonable prospect of success, which is probably the lion's share of how these things are decided. Then there's a proceeding would not further the purposes of the code. So maybe, let's say there was an employment relationship, there was a termination, The individual has alleged that it's discriminatory termination. They filed a complaint. The employer looks at it and says, yep, we screwed up. And then they proceed to say to the individual, we have screwed up. We acknowledge that what we did was wrong. Are you interested in coming back? No. Or yes, as the case may be. But if it's yes, they have the job, there's really no point in the hearing in those circumstances. If it's no, then then the employer might say, well, okay, we're prepared to give you X dollars, which, is in our view in line with what the tribunal does with this kind of thing, and we'll do this and we'll do this, and we'll give you a good letter of reference to help you get another job and so forth. So what is the tribunal, what's a hearing going to do in those circumstances except use up tribunal time and maybe make the individual who got fired feel a little better about things? But it also means there's a great deal of time being used up, and there's only 8 members of the tribunal. So we, in those circumstances, would probably allow the dismissal. Or it might be that there was a settlement, and one party or the other has tried to reject the settlement after the fact. That's another scenario which can be determined on the basis that the proceeding wouldn't further the purpose of the code. We don't want to encourage people to breach settlement agreements. Or it might be improper motive or bad faith. Sometimes people bring a complaint because they're mad at somebody, not because they're genuinely aggrieved by what occurred. And, that's a tough one to make. You really have to be able to bring facts to bear which would support that that's what's going on. And so it's highly unlikely a respondent succeeds with that, but there are a few times when that's occurred. And then there's timeliness, and we talked about that earlier. But it can, in addition to that screening process at the front end, it can be the basis of an application to dismiss later on in the process.
Can you dismiss some of the allegations on, like, if some of these grounds apply and let the other ones?
Yeah, do that all the time. It's another good question. Sometimes you'll look at it and say, okay, this, and this, you really aren't going to get there. There's highly unlikely that this would get there. And you're using your judgment, in my case, as a guy that's litigated for 35 years. Is this likely to succeed? No. Is this likely to succeed? Well, I can't say it isn't. This is something that should go to a hearing. It might. And, and the test is sort of a sliding scale. It's not sufficient that it might succeed. Neither is it sufficient, you're not looking, you don't have to be convinced that it would succeed. It just has a reasonable prospect of success, or it doesn't. So those are things that are, do take up quite a bit of our time. Going back into, I've really talked about mediation already, but enforcement is an area I didn't talk about. You make settlement agreements, and this is also true of remedies, after a hearing under the code. The tribunal doesn't enforce our orders or settlement agreements, but what we do is file them with the court, and the court enforces them. Okay, so probably not a ideal situation from the perspective of somebody who has an order in their hand and the respondent says, well, forget it. You'd love it if we'd step in and bring the hammer down, but the legislation says we don't have that authority. It's the court that has that authority. So, and the court's good at it. People generally pay attention to court orders, and they have things like contempt, and jail time if eventually you don't comply. We don't have any of those kind of sanctions. So it works. Let's see, with respect to hearings, like I said, it's very much like a court proceeding. If you get there, it decides the substantive issues between the parties that are left after all these other processes have been gone through. There are relaxation of rules of evidence, but if you're ever involved in a hearing, it's still going to feel very formal. It just is. And it provides the remedies. Usually a hearing is in one part. The substantive issues are determined, and then argument is made with respect to remedy as well. And the award has all of those elements in it, the decision. Just as in the Winklemeyer case that was raised. It's also possible to do what they call bifurcation. You get a very complex substantive issue, and by agreement, the parties can agree that that's going to be heard, and there'll be a decision on that. If the complaint is successful, there'll be a new hearing that will relate to remedy. And it's just sometimes a more streamlined way of dealing with things. Remedies are interesting. You get obligatory declarations of a violation of the code if the complaint is successful. If it's not successful, we're obliged to dismiss. You get what I would call make whole orders. So that might mean wages if there's been a termination of an employment relationship. It might mean, any number of things that, if, for instance, there may have been a denial of benefits because the individual was terminated in circumstances in which they ought not to have been terminated, and if they hadn't been terminated, they would have received benefits over the past 2 years before you get to hearing, and maybe even, depending on the nature of the disability, maybe even benefits going out, until they reach the age of retirement. So those are the kind of things that, we can deal with. But I have to say, when it comes to wages, that if you have a complaint that's essentially about being terminated, the courts are more generous than we are when it comes to, generally, to wage loss.